2015 didn't end up being the best AFL season if you're a Collingwood fan, but for two die-hard Magpie supporters, it ended up being a good season for other reasons. Two sisters befriended Mrs Evans many years ago at a Collingwood match. In the case of Bailey and Richardson, the two sisters applied for a statutory will to be approved by the Victorian Supreme Court. This is the first case that's been heard under the new legislation dealing with statutory wills in Victoria, and in this instance the court had to consider three main factors. The first of those factors was looking at whether Miss Evans had testamentary capacity. That was quite easily determined by the court because she had lost testamentary capacity and there was expert evidence to that effect. The second of those factors was actually looking at what her testamentary intentions would be, or what they could reasonably expect it to be. And then the third of those factors would be to make a statutory will that was considered to be adequate and reasonable on those bases. The court went and had a look at the evidence surrounding the circumstances, and to assist them with this process they actually appointed an independent lawyer. The independent lawyer made a number of meetings with Miss Evans, asked a number of questions and took as much evidence as possible from her to try and work out what her testamentary intentions were. This was, however, quite a difficult exercise because she was suffering from dementia and wasn't able to give the clearest of instructions. The court was also able to look at evidence that was put in by the two sisters and also looked at Miss Evans' extended family, noting at the same time that while there was a niece and other distant relatives who would be the people that would take if there was an intestacy, there was very limited contact with those people. What the court ended up doing was looking at those factors and satisfying themselves that it was reasonably likely that Miss Evans' testamentary intentions would be to adopt the will that was put forward to the court. Now, that will that was put forward to the court appointed the two sisters as executors, and then it left the estate equally between the two sisters. The court was content with that and made a statutory will on that basis. Now, this court decision is quite an important one for us in the succession planning space. The reason for that is we're often presented with situations where a client has lost capacity, and there's often an assumption that nothing can be done from that point in time, and the laws of intestacy, which is a statutory formula which divides their estate, will take effect. This case is a clear precedent to show that in some circumstances the courts can approve a will, and what that will do is it will give certainty to the parties about how the estate will be left and who the executors are. It can also avoid the unwanted operation of the intestacy provisions if that doesn't reflect what the testator's intentions are expected to be at the time, as was this case. It also provides us with an opportunity to put structures in place regarding a will, and that might be an instance where a testamentary trust, for example, is a great benefit because that can provide asset protection for vulnerable beneficiaries. It can also provide a lot of tax planning opportunities. Well, that's a quick snapshot on the new statutory wills provisions in Victoria. Thank you.